Hello everyone, myself Neeraj Tiwari, Assistant Professor at National University Delhi. Welcome to MOOC course on Criminal Justice Administration. I am here before you to present the module on Rights of Arrestee. I hope you have gone through the module on arrest process. This module is in continuation to the earlier module. Let us begin with the learning outcome. The first and foremost learning outcome of this module is to make the learners aware of those constitutional provisions which provide for safeguards of rights of arrestee. Second, the module will also highlight those statutory safeguards which are provided in the Code of Criminal Procedure 1973 against arbitrary arrest. The module will also expound on those safeguards which are available at pre-offence arrest and post-offence arrest. And lastly, the module will also explain those judicial decisions which have helped in shaping the process of arrest and rights of arrestee. Introduction. The law of arrest is one of balancing between the maintenance of peace and order in the society and protecting the life and liberty of individual on the other hand. It is this conflicting interest which requires reconciliation. The arrest procedure should not be more regressive in nature. The procedure of arrest should be such which prevents unnecessary arrest on the one hand and provides safeguards at the time of arrest and afterwards. The journey of evolution of law on arrest is a fine example of maintaining balance between these conflicting interests. The Code of Criminal Procedure is equipped with various safeguards to protect the rights of arrested person. Under the change regime, the power of arrest is rationalized. Now the police is made accountable for every arrest made by them. Before we proceed to discuss various safeguards which are available to an arrested person, let us first discuss the meaning of arrest. You will be surprised to know that this term arrest is not defined anywhere in the Code of Criminal Procedure. But we can take a clue from the dictionary meaning of the term arrest. The dictionary meaning of arrest refers to exercise of the power to deprive a person of his or her liberty, the taking or keeping of a person in custody by legal authority, especially in response to a criminal charge. Such definition of arrest covers only one type of arrest, but there are arrests which are preventive in nature, where the person or the individual is arrested on a mere apprehension of him committing any serious offense in future. Therefore, arrest may be defined as that process which leads to apprehension of a person by legal authority resulting in deprivation of liberty. Now let us discuss the kinds of arrest. Arrest may be categorized into two broad categories. One which is preventive and another which is punitive. As far as Code of Criminal Procedure is concerned, arrest may be categorized as pre-offence arrest and post-offence arrest. These kinds of arrest may be understood well by this flowchart. So preventive arrest, which is also known as pre-offence arrest, is discussed under clause 3 to 7 of Article 22 of the Constitution as preventive detention. At the same time, Section 151 of Code of Criminal Procedure also deals with preventive arrest. The NCRB data in 2015 shows that 3,200 people were held in administrative detention in Indian jails in December 2014 itself. On the other hand, the punitive arrest or post-offence arrest are provided in Section 41, 42, 43 and 44 of the Code, wherein powers to arrest are given to police officer, to magistrates and to a limited extent even to private persons. So friends, as we have seen, in case of pre-offence arrest, police officer can arrest anyone who he thinks or has knowledge to be involved in the commission or in the design to commit any cognizable offense. And for such an arrest, he does not require the authority or order of a magistrate as well. Though once he is arrested, the subsequent procedure to be followed in his case is the same as given in section 57 of the Code of Criminal Procedure. On the other hand, with regard to the post-offence arrestees, it is the magistrate, the police officer, and in a limited extent, even the private persons are conferred with the authority to arrest some persons. This categorization of individuals on the basis of pre-offence and post-offence arrest will also tell us in the coming slides that how and what type of safeguards are available to them, how they are protected once they are arrested, or even what are the rights they have at the time of arrest. So before we move on to discuss that, let us first discuss who can be arrested under the Code of Criminal Procedure. So as we have discussed in the earlier part in the kinds of arrest, that commission of crime is not a sine qua non for making an arrest. Even at post-offence arrest, it is the seriousness of offence which determines whether a person is to be arrested or not. Prior to the amendments of 2008 and 2010, the commission of a cognizable offence was the sole criteria for making an arrest. But post these amendments, the arrest process has become more rational, and now the police officer needs to further satisfy more parameters before making an arrest, even if a cognizable offence is committed. So on this basis, I have categorized the persons who can be arrested under the Code of Criminal Procedure into three broader categories. These are: 1. Who is more susceptible to arrest, and this category covers persons falling under subclauses A, BA, C, D, E, F, G, H and I of clause 1 of section 41 of the Code. Below mentioned are the individuals who fall in these clauses and who are more susceptible to arrest. The second category of people are those who are less susceptible to arrest. Subclause B of section 41, subclause 1 discourages routine arrest and provides that persons who are either involved in or suspected of committing an offence which is punishable with 7 years or less punishment shall not be arrested at once. The procedural requirement under subclause B must be fulfilled before making any arrest for the offences falling under this category. And last are those who are least susceptible to arrest. Law protects certain persons from arrest. In this regard, section 45 of the Code exempts members of armed forces from arrest for the acts done by them in discharge of their official duty. So we have seen that who are the persons who are more susceptible to arrest, who are the one who are less susceptible to arrest, and who are least susceptible to arrest. In case of first two categories, it is basically the nature of offence and the punishment prescribed for those offences which determines whether they are more or less susceptible to arrest. So friends, we have just finished the part 1 of this module, and in this part we have discussed the meaning of arrest, the kinds of arrest, and the people who can be arrested. In kinds of arrest, we have seen that there are primarily two types of arrest: one, the pre-offence arrest, and another, the post-offence arrest. Similarly, in case of people who can be arrested, we have seen that the Code of Criminal Procedure bifurcates such people into three categories: one, who are more susceptible; second, who are less susceptible; and third, who are least susceptible to arrest. In this segment, we will discuss the significance of rights of arrestee. We will also discuss whether types of safeguards provided in the Code of Criminal Procedure, which are institution-centric and arrested person-centric rights. So to begin with, let us discuss the significance of rights of arrestee. In case of an arrest under the warrant, the chances of misuse of power is quite less, because in such cases, before issuing the warrant of arrest, the judicial mind is already applied and the magistrate has already made up the mind by going through the material before him whether the decision to issue warrant of arrest is right or not. So in those cases, the chances of misuse of power is very less. But in case of arrest without warrant, subjectivity comes in, where the police officer at his own discretion decides when to arrest and when not to arrest. Therefore, in such cases of arrest without warrant, the decision does not come under the judicial scrutiny unless the person is brought before the court. Therefore, arrest without warrants requires greater protection and scrutiny of the court than in comparison to arrest under the warrant. In this context, the observation made by Chief Justice of India, Justice M. Venkatacharya, in the case of Joginder Kumar versus State of UP is apt mentioning. He observes that arrest and detention in police lockup can cause incalculable harm to the reputation and self-esteem of a person. He emphasized that no arrest can be made in a routine manner on a mere allegation of commission of an offense made against a person. It would be prudent for a police officer in the interest of protection of the constitutional rights of a citizen and perhaps in his own interest that no arrest should be made without a reasonable satisfaction reached after some investigation as to the genuineness and bona fides of a complaint and a reasonable belief both as to the person's complicity and even so as to the need to effect arrest. Denying person of his liberty is a serious matter. Justice Venkatacharya further observes that no arrest can be made because it is lawful for the police officer to do so. The existence of the power to arrest is one thing, the justification for the exercise of it is quite another. So friends, we have noticed that Justice Venkatacharya has made a very valid point. If the law has conferred the power to arrest without a warrant on a police officer, that doesn't mean that he should arrest every person in all the cases. But he should ask certain questions to himself, like why arrest, what purpose it will serve, why it is needed. All these should be asked or looked into before making that decision to arrest in a case where cognizable offense is committed. Now we will discuss various safeguards which are available to a person under the Constitution and under the statute. So to begin with, we'll first take up the constitutional parameters with regard to protection of arrested person. Article 22 of the Constitution is the article which talks about arrested persons, and there are certain rights which are conferred on an arrested person by this article. Clause 1 of Article 22 talks about two things. One, that every person who is arrested must be informed the grounds of arrest. It says as soon as he is arrested. Therefore, it can be read as forthwith. So the moment the police officer makes arrest, he is duty bound to inform the person the grounds of arrest. Secondly, Article 22 Clause 1 also talks about the right of the person to be defended by a lawyer of his own choice and right to consult a lawyer. In this way, Article 22 talks about the presence of lawyer at two different stages. When it talks about presence of lawyer for consultation, it talks about a pre-trial stage during interrogation, investigation. Whereas when it says to defend by a lawyer of his own choice, it talks about or refers to the stage of trial. Therefore, these vital rights which are conferred on an arrested person through Article 22 subclause 1 are primarily to safeguard his interest not only at pre-trial stage but also during the trial. Similarly, clause 2 of Article 22 is also very pertinent to mention. More than a right, it confers a duty on the police officer who has made the arrest. It says that every person who is arrested by a police officer must be produced before a magistrate within 24 hours, excluding the time spent on travel. We'll discuss a similar provision is there in the Code of Criminal Procedure in section 57. Now the statutory framework of safeguards are divided for the convenience of our understanding into two parts. One, the institution-centric safeguards, and second, the arrested person-centric safeguards. So first we will take up the institution-centric safeguards, and these are duty to communicate grounds of arrest. Section 50 of the Code of Criminal Procedure talks about duty on the police officer who is effecting arrest to communicate the grounds of arrest to the person forthwith. It also includes the very accusation, the charges, or the nature of offence for which the person is to be arrested. The newly inserted section 41(c) provides for establishment of control rooms. The control rooms will be established at district level in every state. These control rooms will have a list of persons who are arrested with a detail of the police officer who has effected the arrest. This will help the people to know who are arrested and by whom. Another important duty which is cast on the police officer is reporting of arrest to the district magistrate. Section 58 of the code provides that every arrest must be informed to the district magistrate in cases where the arrest is made without warrant. The police officer must also communicate to the district magistrate whether the person is released on bail or he is kept in custody. In discussing institution-centric rights, we should also discuss the duties of a police officer. And while discussing duties of a police officer, it becomes inevitable to not to refer the case of D.K. Basu. The Code of Criminal Procedure Amendment Act of 2000 Act has included all the recommendations or the guidelines given under the case of D.K. Basu. In the case of D.K. Basu, the Supreme Court has come up certain guidelines. These guidelines also talk about the processes or the procedures to be adopted at post-arrest stage. So guidelines 1, 2 and 3 of D.K. Basu case are codified in section 41(b), which lays down the procedure of arrest. It requires that the police officer making arrest must bear an accurate, visible and clear identification of his name, which will facilitate easy identification. The police officer must prepare a memorandum of arrest which shall be attested either by the member of the family of the person arrested or by a responsible member of the locality where the arrest is made. The memorandum of arrest must be countersigned by the person arrested. In case where the memorandum is not attested by a member of his family, the person arrested shall be informed of his right to have a relative or a friend named by him to be informed of his arrest. Guidelines 4 and 6 of D.K. Basu case form part of section 50(a), which obliges the police officer making arrest to forthwith inform the friends, relatives or such other persons disclosed or nominated by the arrested person for this purpose about the arrest and place where the arrested person is being kept. To ensure that the police officer performs his duty without fail, subsection 3 of section 50(a) makes it mandatory to enter the details such as the name of the person informed of the arrest in the book maintained in this behalf in the police station. Interestingly, subsection 4 of section 50(a) provides for judicial oversight over exercise of executive power. The magistrate, on production of the arrested person, must confirm that the arresting authority has complied with the procedure laid down in subsection 2 and subsection 3 of section 50(a). So friends, these were the set of institution-centric rights or safeguards provided in the Code of Criminal Procedure. Now we will move on to see what are the arrested person-centric rights or safeguards provided under the Code of Criminal Procedure. Such safeguards will be discussed under 5 different heads. First and foremost, and very vital or important safeguard is the protection of the arrested person before the magistrate. As I have told you, Article 22, subclause 2 already provides that as soon as the person is arrested, without wasting time, within 24 hours of his arrest, he must be produced before the magistrate. A similar provision is found in the Code of Criminal Procedure in section 57, which confers similar obligation on the police officer. Second important safeguard, which was not present when the code was enacted in 1973, but which was introduced by an amendment in the year 2008, is that of right to counsel. The accused person's right to counsel during the trial has already been set as a right under Article 21 of the Constitution. But the accused person's right at the pre-trial stage during interrogation has been debated quite a bit. But in the year 2008, such a right was introduced in the form of section 41 capital D, where an arrested person can have his lawyer on his side during the interrogation. But the law prohibits the presence of lawyer throughout the interrogation. A detailed discussion on this right is given in the e-text, where cases like Nandini Satpathy, Pool Pandey, Ajmal Amir Kasab and Jugal Kishore Samra are discussed. These cases will help you to further understand the topic in a more detailed manner. Third important right is that of right to information. As we have discussed in the part of the duty on the police officer to inform the arrested person of every particular of his arrest, be it the grounds of arrest, the nature of offense or accusation against him, everything must be informed to the arrested person. And when he is arrested for a bailable offense, it is the duty of the officer to inform him his right to be released on bail on serving security or bond. Additionally, the arrested person has right to nominate any person, be it his relative, his friend or family member, to know the grounds of arrest or about his arrest and where he is kept. All these informations must be supplied by the police officer to such nominated person. Fourth important safeguard is that of the right of the arrested person to be medically examined. Section 54 of the Code of Criminal Procedure provides that every arrested person must be medically examined by a registered medical practitioner. Such a safeguard is to prevent any case of custodial torture. It is required that such certificate must be provided in hard copy to the arrested person. And lastly, the safeguard is that of no unnecessary restraint must be caused while making arrest. Section 49 of the Code of Criminal Procedure prescribes that no unnecessary force must be used or no unnecessary restraint should be used while making arrest. So it keeps the arrest process as a more dignified process and not leading to inhumane or a shameful process. So with this, we reach to the end of the second segment of this module. So in this part, we have discussed about various safeguards provided under the Constitution as well as under the statute, that is Code of Criminal Procedure. And in case of criminal procedure, we have further seen that how these safeguards are divided into institution-centric and arrested person-centric. We have also discussed in this segment the very significance of these safeguards. Now with this, we will move on to the third segment, and which is the last segment of this module. In this segment, we will scrutiny various judicial decisions and that how they have shaped the law on arrest as it appears in its present form in the statute book. Though a series of directions have been issued by the Supreme Court, from Sheila Berse to Joginder Kumar to D.K. Basu, these directions have been inserted in the Code of Criminal Procedure by amendments which are made couple of times. But the ground reality remains the same. The police continue to ignore the procedural requirement for making arrest. Even the post-arrest procedures are not given due consideration, and they all remain mere paper formality. The hope for improvement has come up with the case of Arneshtee Kumar versus State of Bihar in the year 2014, when the Supreme Court had taken cognizance of this issue afresh. Quoting what Justice Chandramouli K. Prasad has observed in this case, that the police have not come out of the colonial image and they are using arrest powers as a tool of harassment and oppression. The bench came heavily on the magistracy as well. It was observed by Justice Chandramouli K. Prasad that detention beyond first 24 hours must be ordered with great care and caution. The endeavor of the court was to ensure that the police officer do not make any arrest unnecessarily. At the same time, even the magistracy do not give any person for further detention in a routine manner. To achieve this, the Supreme Court has issued 8 important directions. I have summarized these directions below. So, requirement of a checklist as per section 41 capital A is made mandatory. No automatic arrest. The police officer is required to fulfill the parameters given in section 41. The checklist, along with material and reasons for making the arrest, must be produced to the magistrate at the time of production of the arrestee. The magistrate must examine the reasons supplied by the police officer at the time of deciding whether to order further detention of the arrestee or not. Even in case where police officer decides not to arrest, such decision must be forwarded to the magistrate within 2 weeks of the institution of the case. Notice of appearance as per section 41A must be served on the person within 2 weeks from the date of institution of the case. Interestingly, in this very year, in 2018, the Delhi High Court has issued guidelines where they have come up with a pro forma for 41A notice. It has been observed by the Delhi High Court that the police officers are not giving any written notice under 41A, and it is an oral communication which is made between the police officer and the person concerned. Such pro forma can be accessed in the case of Amandeep Singh Johar versus State and City of Delhi. It's a 2018 Delhi High Court case. The following data taken from NCRB report Crimes in India of 2015 shows a very positive sign and a very right impact of Arrestee directions. This is a report which has just come out after the direction in Arneshtee Kumar case were issued on 2nd of July 2014. So I have traced the trend of arrest in 2 significant cases. In both the cases, the punishment is less than 7 years. One is a case under section 498A and another is data related to case of theft. So as you can see, in the case of section 498A, from 2011 to 2014, the graph with regard to number of cases as well as number of arrests is on an increase. In 2011, where the number of arrests were 1,80,701, has reached to 2,25,648 in the year 2014. But in the year 2015, we can see a downfall in the total number of arrests, which has reduced to 1,87,67 only. Though we can also see that there is a slight reduction in the number of cases in 2015 in comparison to 2014, but when we compare this with the reduction in the number of arrestees, this shows that it has least impact on such reduction. One of the reasons for such a steep fall in the number of arrestees in case number 498A could be the directions issued in Arneshtee Kumar case. Similarly, in case of theft, the data is also positive. Again, if you see from the year 2012 till 2014, there is a rise in the number of arrestees and even the number of cases registered under section 378, that is theft. But in the year 2015, there is a steep fall in the number of arrestees, which has reduced by 30,000 approximately, though there is a rise in the number of cases registered in 2015. So in case of theft, we can see that though the number of cases have gone up, but the number of persons who are arrested have come down. This again could be an indication of implication of Arrestee direction. Now friends, the judiciary has not stopped at Arrestee Kumar only. Post Arrestee Kumar also, we have seen two cases by the same bench in the year 2017 and 2018 which have direct bearing on the law on arrest. One being the case of Rajesh Sharma versus State of UP, where the Supreme Court has suggested constitution of family welfare committees for the cases under section 498A. The Supreme Court has also observed that no arrest should be made unless the report is submitted by such family welfare committee. On the other hand, in the case of Dr. Subhash Kashinath Mahajan versus State of Maharashtra, which is a case under SC/ST Prevention of Atrocities Act, the Supreme Court has made following observations with regard to the arrest process. Where the arrest of a public servant is concerned, the Supreme Court has observed that prior permission of the appointing authority is must, whereas to arrest a private person for an offence under SC/ST POA Act, prior permission of Deputy Superintendent of Police is required. So in these two cases, we have seen a trend to discourage arrest in first go or in first instance, and there are various checks and balances which are introduced by the Supreme Court in these two cases, though these cases were open for heavy criticism for various reasons. So friends, this takes us to the last part of this module, and that is summary. So let us go through what we have discussed in last half an hour or so. So we have seen what is the meaning of arrest, how arrest to be made, who are the people who are more susceptible or less susceptible to arrest, what are the significant safeguards provided under the Constitution and under the Code of Criminal Procedure for the arrested person, and most importantly, we have also discussed that how judiciary through various cases have shaped the law on arrest and the safeguards for arrestee for all these years. So we can say that it is the judiciary which has marched ahead of legislature as far as protection of rights of arrestee is concerned. The introduction of necessity principle and notice of appearance clause in the Code of Criminal Procedure and directing the police officer to record reasons for arrest has further strengthened the safeguards which are present in the Code of Criminal Procedure against arbitrary arrest. So I hope you have enjoyed this lecture and you have enlightened further on the topic, that is rights of arrested person. Thank you.